Yeah, it is good.
Yeah, you can admit everyone.
10 o'clock.
Yeah, let's start. Chandrika, you can start the video. Hi, I'm Kasturi Thiru, and I welcome everyone to the seminar on behalf of SACEM. Our program today is Law and You. Joined with us today are experienced law professionals from our community. This session is all about giving a general understanding of the tools available in our justice system, and most importantly, when to seek legal help. As many of you are regular attendees, you're probably aware of SACEM. For those of you who are new, SACEM is a 30-year-old organization helping our community thrive within the fabric of Canada. SACEM focuses on overarching needs of the present within our community. SACEM was launched during a time when large groups of Sri Lankan refugees were arriving in Canada. We assisted them with immigration procedures, temporary housing, and employment opportunities. As the community established itself, we conducted information sessions to help people adapt to Canadian society. Recently, SACEM has acquired more young talent on our board. They have been collaborating with our senior leaders to evolve the organization. I would like to welcome our new additions to the board. Dinoja Mariampillai, Sanjayan Sivanathan, Jaduri Sivanathan, and Anojini Collins. We are pleased to have you as part of the team. We are so grateful for the steadfast support and generosity of Chapel Ridge Funeral Home for sponsoring our program today, and their commitment to building an empowered and enriched society. Now, for a few housekeeping items. If you have any questions for the panelists while the session is in progress, please put them in the chat. We will try and answer as many questions as possible within the time allotted. We will have a short survey towards the end of the session. We request your response as they help us with our future programs to be better. We value any new and innovative suggestions for our future programs as well. You can connect with us by visiting our website at sacem.ca or join us on social media platforms like Facebook, LinkedIn, and Instagram. With that, I would like to introduce our moderator for today's session, Ms. Dinoja Mariampillai. Dinoja completed her undergraduate in business marketing at York University. She completed her legal education with dual JD at the University of Windsor and University of Detroit Mercy. She joined the Ontario Bar in 2018. Dinoja has served her legal profession as an in-house legal team member in the corporate sector and later started her own practice, Glassbox Law, serving clients in family law and residential real estate. She is also a co-founder of Aiden Angel Foundation, a not-for-profit helping children and families affected by cancer or terminal illness. She recently joined SACEM as a board of director. Again, she is the most appropriate person to moderate today's session. Over to you, Dinoja.
Thank you for the introduction, Kasturi. Good morning, everyone. I'd like to welcome you all to SACEM seminar about the law and you. The purpose of this program is to give you a better understanding about certain areas of law that can sometimes be confusing and difficult to grasp. This program will provide somewhat of an introductory overview on areas such as family, real estate, wills, and provincial offenses. We hope to provide more programs that will expand on different areas of law in the future and have more extensive conversations about each particular area. As Kasturi has said, this is meant for educational purposes only and is not intended to provide legal advice in any way. We have some very knowledgeable speakers with us today. We will be joined by Lawson Thanapalan, Vida Ramachandran, Abhi Singam, and Paul Balram. They will be all talking about various areas of law. There will also be a Q&A at the very end, so feel free to send in your questions as we go along for our panelists. Without further ado, I'd like to introduce our first speaker. Lawson Thanapalan completed his undergraduate degree at the University of Waterloo in criminology and went on to the University of Windsor to pursue his law degree and was called to the bar in 2019. Lawson has been working with the firm Coach House Law with a focus on family law, litigation, and real estate. Lawson is very knowledgeable in all things family law and will be providing some information in that area. I'm going to now hand it over to Lawson.
Thank you, Dinoja. Good morning, everyone. And thank you, SACEM, for having me here today. So in the interest of time, I'm just going to hop right into my topic and my discussion, which is alternatives to court and litigation when it comes to family law. Family law is a very intricate situation, and there's a lot of nuances involved in the process. But the common misconception that I realize or I see is that many people believe that family law means getting a divorce, or family law means an adversarial process where you go to court and you litigate it. But there are many options and avenues you can take if you do decide to go that route. There are sides to the spectrum. One side of the spectrum is alternative dispute resolutions, which I'll refer to as ADRs, which provides the parties involved with more autonomy in the process, and it could be more cost efficient. On the other side of the spectrum, we have court-oriented litigious and adversarial process, which provides for less autonomy of the parties and can be an expensive process. In terms of my practice, the first thing I always recommend to my clients when they first come in for a consultation or intake is to kind of cool down and take some time for yourself and decide how you want to proceed. If reconciliation is an option, then explore options to save the relationship, such as counseling. Many times I've had clients come in for an intake or consultation, and in the heat of the moment, they want to make drastic decisions, issue an application, but partway through the process, they get tired of it, or they're not able to afford it, or they want to reconcile and they drop the process. And they would have just spent thousands of dollars to initiate this legal proceeding. If you want to proceed with your process of separation, the next question to ask is, or consider, is look into the relationship between yourself and your partner. ADR options are not suitable or reasonable for everybody. If there's abuse involved in the relationship, if there's hostility or intimidation, ADR is probably not the best option, in which case it is better to proceed via court. So if you're of the opinion that you and your partner can work together, then sit down and have a discussion as to what each party wants and they're looking for in separation. Make a list. The first avenue that many people, it's becoming more common now, is a separation agreement, which is a lawyer-to-lawyer negotiation approach. So both parties would hire their own respective lawyers to represent their interests, and the lawyers would basically be your foreperson. He or she would engage in many discussions with you to determine what you want, what you need, and what you're willing to concede in the separation process. Once there's an understanding, the lawyer will usually reach out to the other lawyer with a memo of sorts listing your interests, at which point there'll be rounds of negotiations between the two lawyers, and your lawyer will provide you with legal guidance as to how to reach a resolution on all the issues. Once there's an agreement on the points, a separation agreement is usually drafted by one of the lawyers, and the other lawyer gets to review it and make notes and comments as to represent his or her client's interests. What's being commonly used at this point in terms of separation agreement is with parties that are really amicable and they're okay and they're agreeable on all the issues, they kind of hire one lawyer who does all the work and drafts it up, and then they have the other party review it with a separate lawyer for independent legal advice. And once you receive independent legal advice, the lawyer usually signs off on a certificate stating that he has provided you with legal advice as to the issues and that you're aware of what you're signing and that you're doing so on your own free will. Now, the issue that I'm seeing, especially in our community, is that parties coming into our office looking for a separation agreement, and the deal is being made completely lopsided. So it's a one-sided deal. Now, everyone is their own person and they could make their own decisions and they can make their own deals. However, the risk associated with a very lopsided agreement can be very high. For example, I had a husband and wife who had come into our office. They were very amicable. They were married for over 20 plus years. They were over the age of 60. And the wife decided she wanted to end the relationship. Now, the husband was a very wealthy person. He was a CEO of a big corporation. And the wife was a homemaker, and she always was. And they had kids. My client was the husband. So when we first represented him, the first thing we advised him was we created a list of all the rights the wife had and advised them that what he's offering her or what she's willing to take is far less than what she would get if she were to take this to the court. The husband advised us that they were very amicable and the wife was okay with everything. And, all they want to do is sign off on this agreement and get it done with. So after rounds of negotiations with our own client, we decided to create a memo to let him know that the issues that may arise if he were to proceed this route. After many discussions, we drafted the separation agreement based on his instructions to us. But in order to protect our client, and this is something you should be aware of and look for in your agreements, is we try to bulletproof the agreement as much as we can. And what I mean by this is I made sure the financial disclosure was frank, full, and adequate. This is the first mistake that I noticed in a lot of separation agreements. The financial disclosure is very inadequate. People may just give their word, or they may just give a notice of assessment or income tax return at most, and call it that and add it to the end of the separation agreement. Many people believe that they're protecting themselves by not disclosing much of their income or their assets, but in fact, they're only hurting themselves in the long run. So if after the agreement is made and executed by both parties, and your partner comes to find out that there's an asset or a home or a cottage or a vehicle or some income where you work somewhere else that he or she was not aware of, they can take you to court and claim the agreement is null and void and seek the necessary compensation for it. And I've seen this happen many times. At this point, you're paying legal fees to defend your agreement, which you paid legal fees to draft up. So I have seen judges set aside agreements executed by both parties for this reason, when they feel that the financial disclosure was not adequate. Another common mistake that I see is clients say that the other party doesn't need independent legal advice. and the other party agrees and says, yeah, I don't need it. I'm okay with the agreement as is. I'll sign it. I know what I'm signing. In the moment, the parties may feel that way, but a year down the road, things may change. Courts have also set aside agreements if the court is of the opinion that one party did not understand his or her legal rights, was under duress or undue influence. Even if the other party doesn't want ILA, best efforts should be made to make sure that he or she does receive independent legal advice. And in the worst case scenario, sign a waiver. In my client's case, the agreement we drafted, which comes with financial statements and disclosure, was about 400 pages or so. So what we did was we added specific language in the agreement under each controversial section, and we had the other party sign or initial it just to make sure that he or she read that point and was aware of what they were signing. We then pushed the other party to get independent legal advice and referred her to a very reputable lawyer who deals with a lot of separation agreements. The lawyer was pretty much shocked as to like how one-sided the agreement was and tried her best to convince the wife. But at the end of the day, the wife was not willing to listen and wanted to sign the deal. We executed the agreement. And 8 months later, the wife showed up at the husband's house, sitting in the living room, and claimed that the agreement was void, saying that she didn't know what she was signing. And, you know, she tried this separated life out for 8 months and that she wanted to now proceed and continue to live together. She called the police and the police informed her, looked at the agreement, said that she had no right to stay in the house and had her escorted out of the home. She then went to court and filed the agreement in court and said that it should be null and void because she didn't understand what she was signing. And the judge overruled and said, no, you were fully capable and understanding of what was said. You had independent legal advice. You initialed each of the paragraphs. And the judge quoted by saying, a bad deal is still binding in law. So it's an example because our client was adamant that financial disclosure was not necessary. He didn't want to disclose much of his income. He had hidden some stuff. He may have not claimed some stuff, which he didn't want to disclose. But, you know, we had to explain to him that we're not the, Canada Revenue Agency. We're not here to like book him for income tax issues. We're just here to make sure that he does not get dinged, for a better word, for stuff that he didn't intend to include in the separation agreement. So that's one thing I'll say with separation agreements. Make sure your financial disclosure is full, frank, and adequate, and make sure the other party has independent legal advice. No matter how amicable you are, you never know what happens in the future. Another very common option, and it's recently growing, is called collaborative family law. This process involves a lawyer-to-lawyer negotiation as well, but the parties are more involved in this case. Collaborative family law requires lawyers to attend and receive a certificate of practice to practice collaborative family law. Not everyone can practice it. The parties are usually involved in four-way calls with their respective lawyers who will serve as coaches or guidance counselors or someone who's going to guide you through the process. Everyone in this process is actively involved in negotiating and coming to an agreement with regards to children, support, payment, equalization, etc. Collaborative family law, what another positive is they also include third parties. So as necessary. So you may get financial experts come in or parent coordinators come in or accountants come in to provide the parties with their opinion as to how things should progress. So they may interview the child, they may look at your income, and they may say, this is how much you would pay, or this is how much your income is based on the documents you've provided. And it's a way to kind of mediate the issues. Now, collaborative family law is not for everyone, especially if the parties, like I said, do not get along. At the start of collaborative family law, lawyers usually have you sign an agreement affirming that they will not go to court nor threaten to go to court to resolve the issues while involved in this process. Now, in the process, if you decide that this is something that you cannot come to an agreement with, you would have to withdraw from the collaborative family law process and take it to court. And at that point, your lawyers who are representing you at that point cannot go to court and represent you due to a conflict. Once you are in agreement in a collaborative family law situation, a separation agreement again is drafted, and it's a more hands-on approach. And it takes away the adversarial process. So again, it has to be voluntary, there has to be no hostility, and both parties need to come into it with a mind to resolve. The third option is mediation. It's very similar in the sense that the parties tend to a mediator and they have a even more hands-on approach. Here, there's, a mediator does not have to be a lawyer. A mediator can pretty much be anyone. And the mediator basically helps the parties come to agreements on the issues. And the second section to mediation, some people take is mediation arbitration. In that case, it's kind of the best of both worlds. You get a mediator trying to resolve and giving the parties the autonomy to make the decisions. Now, they may agree on child support and custody, but they may not agree on spousal support. So when there's an issue that cannot be resolved via mediation, the next step would be to take it to arbitration. So it's almost like you're hiring a private judge who then takes it like a court proceeding, and you have to file materials, and the arbitrator will then listen to both sides and make an order based on law as to who deserves what. And then, of course, at the end of the day, we have the courts. This is the most adversarial process, and it involves meeting with a lawyer, telling her his or her your story, and the lawyer then puts your story on an application. This is a time-consuming process, but it's reasonable in certain circumstances. What many people fail to recognize is they think it's a very simple or quick fix, and this can take months, if not years, to resolve. There's less autonomy involved in this process because the judge basically sits and presides over the matter, and they control everything about the process. Once you serve the materials, the other side is given timelines to file their responses. And now if your other party or your ex-partner decides not to respond, which has been in many cases, you can proceed towards an uncontested trial. If at some point he or she does respond to your materials, now you're involved in a more litigious process. It involves court appearances, case conferences, settlement conferences, and trial management conferences before it eventually gets to trial. So these are some options that are available when it comes to family law and separation. It's a very difficult time for everyone involved, and there's a lot going on all at once. But if I can leave you with something, I want to reiterate patience, thinking the issues through, putting the children first, and then deciding the path you want to take. Court is not the be all and end all. There are many options you can take, and there's a saying that I may not completely agree with it, but a judge first told me was, there are no winners in court, there are only losers, right? In a family law case, that holds even more true, because a lot of times they come in with the mindset of trying to resolve issues, and it becomes very emotional and it becomes almost vengeful. The children get kind of put to the side and they're fighting over a lot of minute issues and money. But at the end of the day, what everybody fails to recognize in court is you're spending money to get money. And then at the end of it, the cost benefit is you're kind of in deficit, and the children are the ones that are affected by the process. So even in court now, they have a mandatory rule that as soon as you file an application, they say that you have to attempt mediation or try to resolve the issues. And the court asks you in your first case conference, what have you done to resolve issues or narrow the issues? Because the courts want you to come to court with limiting the issues. If you've had 10 issues and you can limit it to 2, the court and the judge is willing to help you get to that process. But if you come to the court and you file an application and you haven't discussed anything and you're expecting the judge to resolve everything, it's not going to be looked upon fairly. So, it is a difficult process, and how difficult it is dependent on how difficult you make it. So just remember that at the start of this separation process, you have a lot of autonomy, and the longer it takes and the more adversarial it gets, the less autonomy you have, and the more expensive this process gets. So I hope I was able to shed some light on the different avenues available in family law. And with that, I'll pass it back on to Dinoja.
Thank you, Lawson. That was very informative. I would like to go over some housekeeping quickly, which I missed. If you have any questions for the panelists while the session is in progress, please put them in the chat. We will try and answer as many questions as possible within the time allotted. தமிழ்ல உங்களுக்கு questions இருந்தாலும் அதை நீங்க chatல தமிழ்ல போடலாம். நாங்கள் அதை panelistக்கு கொடுப்போம். We will have a short survey towards the end of the session. We request your responses We like to make our future programs better with those. We would also like to thank Chapel Ridge, which I believe we missed the slide. Chandrika, can you bring that on? Thank you. Over to you, Dinoja.
Perfect. Thank you, Kasturi. And thank you, Lawson, for that. That was very informative. Our next speaker is Vida Ramachandran, who is the founder of Ramachandran Law. He completed his legal education at Hofstra University in New York and began his legal career at a full-service firm. His practice area now focuses on real estate, family law, and litigation. He is very knowledgeable about all areas and is usually the first person I call even when I have doubts. So please welcome Vithu.
Hi, everyone. Good morning. Thank you for that very sweet introduction, and thank you, Singam, for the opportunity to present today. So today, our topic, or my topic that was given to me, was talking about property issues within the family law context. Property issues are usually some of the most complex or most litigated upon issues in the family law context. I agree with Lawson in the sense that parents usually forget about the children and end up wanting to see who gets the house, who gets the car, who gets the bigger bow, or whoever gets the most amount of money at the end. But they really lose sight of what they built the family upon. Family law and the property issues is the section where you spent the most amount of money and time. And there's different rules for property division within couples. There are a lot of people here are in common law relationships or not legally married. And you have to understand the family law rules for common law, or even estates rules, when Abhi talks about it later, vary dramatically if you're not a legally married couple. For the sake of this discussion, we'll keep it to legally married couple. If you're legally married, usually you'll have your house that you guys both live in. You may have pensions. You may have vehicles, and sometimes some kind of registered savings accounts for the most part. Upon a separation, either you guys could all agree, and I highly recommend coming to the table and agreeing on the splits or some kind of division through either ADR or some kind of collaborative approach, rather than going to court. Because if you go into court, it becomes that you're putting all your cards on the table and you're letting a third party decide your future. I've had many instances where either clients have completely lost or they've won more than what we've expected. And it is a lose-lose situation when you look at the aftermath of the family. Unlike civil litigation, where it's all about money or breach of contract or telling someone to stop doing something, family law, in family, even when you're done with us, the lawyers, and this process, you still have to probably see each other for another 10 to 15 years, depending on this how old your children are. So we recommend not becoming overly divisive in the process. If you are, so traditionally what's going to happen is that once you split, all the assets that you have in joint names will get split between both parties. And we will do financial disclosure. We'll make sure that everyone sees everything. One of the biggest issues that we're having is, and especially within our community, is a lot of our individuals are either self-employed or intentionally underemployed or employed for cash. So when you have these issues of being self-employed or underemployed or employed for cash, it really starts making this process a lot more difficult and a lot more harder. I tell all my clients, I'm like, if you live with someone for 15 years or 10 years, they probably know you better than you know yourself. and you guys kind of know each other's finances for the most part. So don't come here trying to hide it from the person that you live with for the last 10, 15 years, because you're not helping anyone. Unfortunately, that's what happens though. And what ends up happening is you have this drawn out process, which ends up going to court, and one person loses dramatically and one person wins. And it becomes very nasty and ugly. I agree, for the sake of like the families, especially if there's young children involved, having a much more collaborative approach for property resolution is the best approach. With respect to properties could be anything. It doesn't have to be only real property. It could be financial assets. We're getting into the crypto world, which is a whole new world of issues that it's bringing. So we want, when we get clients, we tell them, please be open and honest with us so we could actually resolve your issues quickly and more effectively. Family law is probably the most expensive type of court procedure or litigation process, and it's one of the most overarching processes because it kind of incorporates real estate planning, contracts, corporations, everything into this umbrella of family law. So with respect to family law and property, please, if you are unfortunately going through this process, please make sure that you go through it with a healthy mindset or with a viewpoint of resolution, especially if there's children involved. With that, I'm going to turn it back to Dinoja, and we'll wait any questions that we receive from the floor.
Perfect. Thank you, Vidhu. That was very good. That was a lot of information. I'm sure you'll have a lot of questions at the end. I'd like to introduce our next speaker at this time. Abhi Singam has over 10 years of experience as a real estate lawyer and has assisted thousands of clients with their real estate, wills, estates, and family law matters. He currently advises clients on a wide range of matters, including purchase and sales of businesses, corporate structuring, residential real estate transactions. I'll now welcome Abhi, who will be providing some information about the importance of wills and things you should consider for your family before having one prepared.
Thanks, Dinoja. Thank you for the invite, and definitely thank you to SACEM for having me part of the panel. I was asked to speak about a couple of things. One, the importance of will. The other one is traditionally what our families miss out or omit to pay attention to when they are preparing their wills. So again, it is unfortunately that I actually had prepared a slideshow presentation, and I kind of realized that it may not be necessary for this session. I'm just going to speak from my slides. Hopefully that's okay. In terms of the will, again, as most of you would know, the will is a legal document that names the people that you want the property and or possessions at the time of your death to be passed on to. Usually, the people that you want to have or want to receive the properties are your beneficiaries. And the properties are, as Vidhu and Vidhu just mentioned a brief while ago, is changing. It is changing in the sense we used to deal with traditional properties like a home, a land, or vehicles, or money in the bank account, etc. Now we are dealing with cryptocurrencies. We are dealing with even social media accounts. So there are definitely challenges with regards to how those things could be passed on even after someone's death, and it's important therefore to have a very well structured will. And I just wanted to quickly go through the process of understanding what happens if you don't have a will. Usually, our traditional belief is that in the event of a death, the property will automatically go to the spouse. And it is normally the case, but it is not always the case, and that's where it gets a bit muddy. And given the fact that our families are in different family structures in Canada and other parts of the world, we need to pay attention to ensuring that our will is obviously able to transfer properties to people that we want to pass on to. So what if you don't have a will? If anyone dies without a will, and there's no valid will as to how the property is to be transferred, there's a government formula as to how that could be then transferred. Again, if you don't have a will and there's no immediate relatives, that's again another problem. It may go to your relatives, but if your relatives are not here in Canada, or if you don't have, if your nearest living relatives are your cousins, your estate will obviously have the possibility of being taken over by the state government. So that's the other thing that you need to keep in mind. But again, just going back to the question of what if you don't have a will, and what happens? What is the process by which the code deals with the will is what I want to talk about. So, in the event you're married, there's the formula is that if you are married, if it is anything less than 350,000 in your estate, usually it is as of March. If somebody died after March of 2021, it will go to the first 350,000 will go to the spouse, and anything over that will be divided between the spouse and the kids equally. But what if you don't have a will, and if you're in a relationship that's not traditional? That's one of the concerns that we have consistently had to deal with, and that's one of the things that I want to talk about. For instance, if you die without a will, and if you had not been legally married, or if you had died and you had adopted a child, if there are other parties, extended family members, for instance, who wants to challenge your adopted child. If you're legally married, but the will was written prior to your marriage, those are some of the challenges that we have seen, and then I just wanted to go over so that when we do our wills, we pay attention to those matters. So, firstly, I want to talk about the typical scenario in which people who are married and dies without a will. What happens then? Usually, the spouse, the surviving spouse, will make the application. Again, we have had situations where the surviving spouse is challenged by children who want to be part of the estate administration process. But usual cases when a spouse dies, the surviving spouse will usually make the application, and the surviving spouse will then be recognized by the court as the estate's administrator. And the estate administrator then will have the option of dividing up the assets, taking into account the spousal survivorship rights that they have, and they will be able to disperse the assets based on who's surviving. So that's the normal case. In the case when a surviving spouse is challenged by children who want to be part of the estate administration, it gets muddier. The normal situation in which we find our clients sort of struggling are, for instance, if there's not a good relationship between the surviving spouse and the children. The children will have a claim over anything that's over $350,000, and usually they will make it a problem, and this makes it an issue. If you have a will, that basically can be dealt with through the will. That's one of those things. The other thing that I wanted to talk about again is the common law situation. We do see people that are either in a long-term common law relationship or short-term common law relationship, where they assume that the common law spouse will have estate rights, and that's not the case. In the event of a common law spouse dying, the surviving common law spouse does not have automatic entitlement to the estate, and there could be challenges from family or others with regards to the estate and the assets in the estate. One other situation that I feel that we need to pay attention to is basically when a separated spouse dies without a will. So in this case, for instance, the spouse that passed away was in a marital relationship. He was legally married to somebody. They separated, but did not go through the divorce process. After 24 years of separation, and during that time, the deceased spouse had a relationship with another person and was involved in a common law relationship, had 3 kids, and then passed away. In this case, the common law spouse was not named in a will, or neither did the children. The original spouse made an application as her marriage had not been nullified or divorced. She had survivorship rights under that Marriage Act, and therefore she actually wanted to claim rights over the assets that were held by the deceased spouse. So this is another typical situation where we feel our families are engaged in. Usually there's a bit of, even now, there's a little bit of a lack of understanding with regards to the need for a divorce, and the fact that they feel that if they had been separated for, as in this case, of 20 years, that the previous marriage will not have any impact, or the wife from the previous marriage should not have any legal rights to the property. But in a sense, that's not the case, and that's one of the things that we need to deal with. So these are some of the challenges that I feel that we need to take into account when somebody's preparing their will. In another situation that we dealt with, a person had prepared the will prior to marriage. The person passed away after being married for almost 4 years. The will that was prepared prior to marriage had named the person's parents as the beneficiaries. So when they passed away, when the person passed away, the parents wanted to claim rights to the property. The spouse that had been in a legally married relationship with the deceased was not advised properly about his or her rights. In this case, the spouse was led to believe that the will, although written prior to marriage, will continue to have effect, and therefore that the surviving spouse should not be getting anything, and the surviving spouse signed off without getting an independent legal advice. We recommended that the surviving spouse actually seek litigation assistance in this matter. But again, this is one of those situations that I feel that people need to pay attention to when they're preparing the will, and they need to keep constantly, it doesn't have to be something that they look at every day, every year, but if there has been changes to their marital relationship, for instance, or if there has been changes to, for instance, who they want to treat as beneficiaries, or if they want to change the estate administration roles, they should be paying attention to those matters as and when it's required. A will does not, it's not something that you want to go back every year, but at the same time, it is not one of those things that you want to just write when you're in your early stages of your life and then just want to forget about it. It is something that you need to make sure is valid, and that basically relies on basically if the estate administrators are still able to function as the estate administrators, if the beneficiaries that you have named in your original will are able to receive your assets, and all of those things. So you need to make sure that you pay attention to those matters. Again, as you have noted, my role here was to just to speak to the need for a will, not necessarily on the other matters. The one other matters that I would just highlight are the powers of attorneys that you would want to create. One obviously to manage your property, and the other one is the power of attorney for your personal care. Those are two documents that go hand in hand with your will, and it usually is packaged by your legal counsels. But I would suggest that those two documents have to be also thought through and thought about when you're preparing the will. Again, I don't want to take up too much of the time right now. I'm sure that when the Q&A is open, and if there are other questions, that I would definitely be more than happy to respond to them. At this point in time, I'll take, turn back to Dinoja. Thank you, Dinoja.
Thank you, Abhi. That was really useful information for everyone to know. Wills are so important. I'd like to introduce our next speaker. Paul Balram is a senior paralegal at PBM Legal Services. He has extensive experience in provincial offenses, insurance charges, small claims proceedings, and landlord-tenant matters. Today, he will be speaking on how to best navigate provincial offenses and insurance claims. I'll now hand it over to Paul.
Thank you, Anuja. Good morning, everyone. And thank you for SACEM to give me this opportunity to speak in this panel. And also I would like to thank all the medias here and all the audience spending the weekend and enjoying with us to listen to all these panel. My topic was given to speak about provincial offense and how the family dispute involved. So basically you have heard all these panelists were talking about how to take the legal action, how the proceeding can take in the family law. Now I'm going to take it to the different angle where what will happen, what are the consequences when the family issues get into assault or any unnecessary disputes. Obviously, that's one of the topics I wanted to take in there, where will be a criminal charge. So in that sense, if the family call for some reason for the husband or wife, call the 911, what is going to end up in? Definitely they are going to end up in calling the police, and the police are involved, then they will be acting at the criminal court. Automatically, the husband or wife will be not to contact directly or indirectly with each other for 6 months. But if there is aggravated factor, then automatically it's going to extend further. But as you all know, once it goes 1 year separation, of course, it's easy to file a divorce. But why do we have to get in there? This is another area I wanted to talk to. So the best thing, I think one of the panelists was talking about counseling. Each individuals could call for counseling and talk about counseling and to avoid this unnecessary dispute and unnecessary criminal charges. But now, the other area I also want to talk, why these families get disputes. It could be alcohol issues, it could be drugs, it could be stress at workplace. That each one will bring it to home and to their spouse and take on them, which is we got to avoid. That is also you got to use the counseling onto this. Once it's come to an assault, once it goes to a criminal case, then the other partner is going to have a criminal charge, which will lead to losing his job, which will lead to their financial burden also. Now, let's One of the addicting is alcohol. Imagine if a person have a drink and drive and operate a motor vehicle, that's also going to lead to a criminal charge. We all have to understand the criminal charges, once it's laid down, especially in Canada, especially Ontario, that stays with them. Now, once the person got criminal charge and due to a drink and drive, the license will be suspended automatically for 3 months. Then furthermore, if he accepts the guilt, that's automatically gained for 1 year. And furthermore, there is a 1 year probation period. All probations are conditionally different circumstances. Now moving into the license suspension. Now I'm going to get into the highway traffic area also about this. Basically, if a people have, once they get the license suspension due to drink and drive, obviously the insurance premium is going to go higher. Guess what? The people start operating insurances without insurance vehicle, or they may get canceled the insurance due to a drink and drive. Now, how important of the insurance policy? It's very important. People have operating an insurance policy. If the premium is $1,000 per month, roughly speaking, people start to operate a vehicle without it.
Sorry, Paul, you got muted for some reason.
Sorry,
Thank you.
I don't know where I have left. Anyway, let's start with the importance of the policy. So when the person gets a policy without a operator vehicle, without a policy, what will happen? The first charge is going to be a $5,000. And the second time is going to be $15,000, and third time is going to be $25,000. On the other hand, due to a drink and drive and operate a vehicle while during the suspension and no insurance policy, that is also going to lead to them a jail term. So those lot of consequences are involved. So where is all happening from the family dispute, stress, and alcohol influence, and workplace stress bringing home? So that definitely everyone need to have the counseling. Moving forward, how much and how each family can avoid this? That's the question they got to figure out. If they cannot, there are a lot of counseling services are available in order to avoid that. Now, if a person operates a vehicle without an insurance, and if he end up in having an accident, then they are also looking for third-party lawsuit, which is the other party who got hit. And in the meantime, if a person operates a vehicle without insurance and damage the property, even though if this is not their fault, and damage the property in a sense in a public property, that is also going to be a collectible. And if they cannot afford to pay, that is also going to lead to suspend their license. The suspension license is a big issue in especially Ontario. The reason being is the license, driving license is a very important issue for each one in this province. Furthermore, when the person got a criminal charge, when they get affected with the criminal charge, and if it is not criminally convicted, criminal charge is different, criminally convicted is different. This is what you do definitely need a counseling and the counsel in order to proceed your cases. Because once they get the criminal charge and has to be taken not convicted or not accepting with criminal charge in order to maintain their government or semi-government job. So that is very important. So my highly recommendations to do not drink and drive, number one. And the other thing is regardless, do not operate a motor vehicle without an insurance policy. I have wrapped up a lot in this where it's very detailed based on the time limit given to me. I just covered up everything, but I am more than happy to help you all and answer to all the questions which is not even covered in this provincial offense area. Thank you for everyone.
Thank you, Paul. At this time, I'd like to invite SACEM's president, Quintus Singam, to provide the vote of thanks, which will then be followed by the Q&A portion.
Thank you, Dinoja. அனைவருக்கும் வணக்கம். இணைந்து கொண்ட அனைவரும் அதிகமான கருத்துக்களை பெற்றுக்கொள்வீர்கள் என்று நம்புகின்றோம். SACEM is always proud to continue to empower our communities in Canada and around the world to achieve heights and gather facts and clarity in climbing the ladder for success. I am absolutely delighted to be part of the Society for the Aid of Community Empowerment, widely known as SACEM. I must mention our deep sense of appreciation for our expert speakers. Today's topics are by far the toughest ones for our group in organizing the panelists. Despite busy schedules, you have set aside time to share your expertise with our community to empower them to make educated decisions. All of you have gone above and beyond our expectations in delivering excellent presentations and sharing valuable information. So thank you so much. You have done a fantastic job. On the media and marketing side, I should thank Dinesh from NLA Express, who primarily helped us with media publicity, and also the IBC Tamil, Pahalavan TV, Mon Tamil TV, EET TV, Krishna TV, GTA Tamil TV, Yuham Radio, NDTV, IPTV, and all other social media platforms that helped us with live streaming the seminar. Well, ladies and gentlemen, an event like this cannot happen overnight. The wheels start rolling weeks ago. It requires planning and a bird's eye for details. We have been fortunate enough to have a team of very motivated and dedicated colleagues at SACEM who know their job and are result-oriented. I am therefore duty-bound to place on record our hearty thanks and appreciation to the individuals who were instrumental in coordinating and executing the seminar. Ms. Rahmatullah Marikar and Ms. Kasturi Thiru were at the backbone and did a stunning job. A big thank you to both of you. And of course, we are thankful to Chandrika, Jude, Seon, and all of the board members as well. I cannot forget our wonderful moderator, Dinoja Mariampillai. A professional moderator ensures the panel discussion runs smoothly, the audience are engaged, and the event hits the mark. Dinoja has done all that and more, and made SACEM proud. Well done, Dinoja. Thank you so much. We are so grateful for the steadfast support and generosity of Chapel Ridge Funeral Home for sponsoring our program today and their commitment to building and empowering and enriching the community. Christine Sivaradnam, who is also a board member of the Canadian Tamil Chamber of Commerce, didn't even hesitate for a moment in saying yes when we approached her. Thank you, Christine. Most importantly, we are so grateful to all the participants today. Without you, this seminar wouldn't have served its purpose. So thank you so much. We are now going to go into the most exciting section of having the panelists answer all your questions. So please stay with us, stay tuned. Thanks everyone. Long live SACEM.
Thank you. So we will begin our Q&A portion. So feel free to send in your questions during the chat as we go along, but we already have a few. So I'll start with the first one. So I guess this will be for Vidhu and Lawson. So the question was, I believe Lawson mentioned collaborative and then arbitration with respect to family law. Can you go into a little bit of detail about the differences between the two, and then how someone would decide which avenue to take and which method would be best for their situation? Maybe we'll let Vidhu start first, since his screen is highlighted right now.
Okay. What you would choose, the path you would choose, will be based on the individuals involved. More than the lawyers involved, it depends on your relationship. It depends on the couple's, I think, sense of maturity towards the fact that the separation is happening, and whether the differences between the two parties are not too weighted against, where it's not too uneven of a playing field. I think, given those circumstances, you could, if you're more of a neutral, most people are more likely to resolve or working towards a resolution and mature about the topic. I think for the collaborative way is way better to go. You could do it through a separation agreement and quickly move it. However, if there's domestic violence involved, if there's a history of violence involved, if there is parties who are vengeful, or people who want to burn the other couple to the ground or other partner to the ground and leave them with nothing, you can't. Those approaches won't work. It takes two to go in the collaborative style, and we'll know as soon as we talk to our client and we talk to opposing counsel what approach we could take, because if both sides are not going to play ball, you're not going to have it. If you're going to have one side who just wants to make sure the other person suffers for as long as they can, you can't have it. So it really depends on the two sides.
Perfect. Lawson, would you like to add anything to that?
Yeah, I agree with what Vidhu was saying. It really is dependent on the parties involved. In terms of differences, what I would say is, collaborative family law is a more hands-on approach. Arbitration is not so. You control kind of the outcome in collaborative family law. So what you put forward and how much you put forward will help resolve the issues. And arbitrations, it's pretty much, like I said, it's pretty much like court. So if the issues are not resolvable, if you think you can't sit down together and have a discussion, then maybe collaborative family law is not for you. Now, this collaborative family law can be practiced in many ways. Some people, if they're really amicable, they're in the same room or the same call. I've seen it happen where what they do is they have breakout rooms. So the one lawyer and the client would be one room, another lawyer, another client, another room, and they kind of go back and forth with discussions. Oh, this is what my client offered, this is what my client offers. Now, the thing with mediation arbitration is it's kind of similar in the sense that you get to mediate it first, and if you think it's not heading anywhere, or if you can resolve 5 of the 7 issues, then the last 2 issues you can arbitrate it. So like I said, arbitration is less autonomy, and it's more like having someone decide your fate for you. So if, say, you decide and you agree upon 5 of the issues and then you can't agree upon spousal support, then the person who was mediating can arbitrate the decision and make file documents, and you'd have to basically in law make a case stating your position is the correct one, and the arbitrator would then make a call as to how he or she would make an order. So it's very similar in terms of an adversarial process, versus collaborative family law is a voluntary and kind of like a teamwork kind of process. So it really depends on how you feel the other partner or your ex-partner and you can handle things together. If you feel that it's very unlikely that you can get something done, then maybe it's not the avenue you want to choose. Or if you want to be, you don't want to waste money with that, and you want to go somewhere where someone is there, a third party who can make a decision or order for you.
Mm-hmm. So can you start with one and then slowly transition into a different one if the one's not working? Say you started with mediation, but it's not going as smoothly as you planned on it. Can you sort of transition to a different approach?
You definitely can. It also depends on the agreement you sign with the mediator. All right. There is a sense that you have to put forth best efforts when you are at a mediator thing. So if you come in there, and then first day you're in there, and then you're like, you know what, I don't want to do this, right? It's going to be kind of frowned upon. So you can obviously you control your fate. You're not in court. Once you're in court, the proceeding is active, right? And if you don't want to take part in court, the proceeding will go without you, right? So in mediation, you can be like, that's why people choose med-arb, right? Or mediation arbitration, is because if they feel they don't want to do this anymore, right? And it's happened many times where fights erupt or arguments erupt, and they say, I'm done. Like, I don't want to be in a room with this individual. I can't agree about it. I'd rather have someone decide for us, right? So then it's a quick transition into being like, okay, fine, we're going to stop this here. And then the mediator put the arbitrator hat on and say, I give you deadlines. So in 30 days, you have to file your materials. In 30 days, you have to file your response. And then we're going to meet again here and try to resolve the issue, kind of like a motion or a trial. So it's totally up to you as to how you want to deal with it. And it varies based on the attitude of the parties.
Okay, perfect. So the next question, I'll direct it towards Vithu just because he's touching on some other property issues within family law. But with respect to the matrimonial home and versus other properties, how are they usually treated differently when it comes to a separation, or even what should people factor when thinking about multiple properties and things like that? And when would that become an issue?
I think a lot of my clients, like I do a lot of legal aid. A lot of my clients have a misconception on what is a matrimonial property. So, for example, both of you have to be entitled. If not, you may have equalization that results in a 50% division of the finances, but you might not get title. Like a non-title owner cannot ask for exclusive possession in most circumstances. So I think it comes with the understanding of, are we married? Are we both entitled? And then what I advise my clients to do is I give them, I'll print out an NFP sheet and a financial sheet. I'm like, okay, start filling this out to the best of your knowledge. Now let's see what you have. Let's see what, and you probably know what the other person has too. Most marriages, other than these maybe these TV marriages, most of them you kind of know what the other person has or what the other person is doing. So you have an idea, and then we can start discussing about resolutions on how to split them. Because one person might say, you know what, you take the house because you have the kids, and I'll take the business. So there'll be like offsets.
Okay, perfect. Maybe I'll direct this next question to Abhi. In terms, I know you kind of touched on a power of attorney. Can you kind of explain what the difference between a power of attorney and a will would be for some of the viewers that might not know? And then also I see a question about standard and non-standard POAs and what the differences might be. Oh, sorry, you're muted.
Sorry about that. So in terms of the difference between a will and a power of attorney, again, power of attorney, for instance, we're talking about both power of attorneys for property and the power of attorney for personal care are important for two reasons. One, if you are physically or mentally incapable of making decisions. In which case the power of attorneys become even more important. Power of attorneys are also relevant when you are not able to make decisions because you're not in the country or you're not able to deal with your property or matters. So the power of attorney only comes into effect before somebody dies. The power of attorney will not be useful when a person dies. So until a person's death, and if the person is not able to, because they are not physically able to make decisions or not in the country, or if they're not able to mentally, they don't have mental capacity to make decisions, right? That's when the power of attorney becomes important. It is effective from the time of signing, So basically, if you were to sign a power of attorney today, appointing another person as your attorney to make decisions on behalf of you with regards to your property matters, then it is effective as of today and will be effective until you revoke the power of attorney. So in most cases, when people go through illnesses and other matters which incapacitates them, they will need some sort of a document which allows another person to make a decision about their property matters. So it could be about selling a property, it could be about getting a mortgage or transferring the property to another person, or renting a property, or even collecting information from land registry or from CRA and that matters like that. So a power of attorney for property deals with all those things, and when that person dies, then basically the will becomes effective. Same way, the power of attorney for personal care basically allows another person to make decisions about your health and well-being. So in a case where a person is not able to make decisions, and usually hospitals do require some sort of confirmation as to who your power of attorney for personal care before they allow them to make decisions, it is important you have a document that states that you wish to have a person or a couple of people jointly or severally appointed as your attorneys to make decisions about your health care. And so when the doctors require to confirm, this document is usually provided as an evidence of somebody being appointed as a power of attorney. Then that person makes basically all sorts of decisions about your health and well-being. It could be about treating you or stopping the treatment. All of those things are then able to be made without your active involvement. One thing that I would like to make sure that people know is that the power of attorney document can also be revoked at any point in time. Let's say you have prepared a power of attorney appointing a person, then you wish to have that changed. As long as you are mentally capable, you are able to change as to who you would like to keep as your attorney for property or for your health care. So that's the very brief gist of what a power of attorney document allows you to do. I'm assuming the question was about continued power of attorney and special power of attorney for a specific purpose. So if the continued power of attorney basically is as I said, is something that allows a person or couple people as jointly or severally to make decisions about your health and well-being or property related matters on a continuous basis. That becomes relevant and useful even if you are mentally incapable during that process. So this allows the attorneys to make decisions. Special power of attorney usually is for a specific purpose, and that is basically appointing a specific person to make decisions about a specific property or matter. So if you want to get a person appointed as the attorney to transfer a property during the time that you are going to be on vacation, or sign mortgage documents when you're not able to sign physically because you're away or you're not able to make the decision. So it basically allows the person to act on your behalf for only a specific purpose, and it is usually it's drafted in such a way that it doesn't become a continuous power of attorney. So that's the difference. And again, if they have more questions, if there's anything that I need to clarify, again, if I miss anything, do let me know. I'll be more than happy to touch on that.
For sure. There's a follow-up because somebody asked about when would be a good time as a young adult to set up a will. Is there a particular time when people should start looking into it? Is it as early as possible?
Well, it's again, I was dealing with this client that was looking at doing some private mortgages, and the individual said that he's got about $500,000 to $600,000, and he's made quite a bit of money through trading in cryptocurrencies, and he's 22 years old. So again, I all the more reasons to start early. At the same time, I need to warn that in the event of changes to your personal circumstances, be that through marriage or divorce or anything like that, or birth of a child, or if you wish to change your beneficiaries, you constantly have to go back to make sure that you change those things. So if you had prepared a will prior to marriage and then you want to rely on that will, 30 years down the road where there's been so many changes in your life, obviously the will that you prepared 30 years ago will not be relevant and will not be useful. So it is important that you start early and have a will so that there's no, and again, it also goes back to the fact that we are living in a very, very how do I say this? A volatile sort of time, and anything could happen to anybody at any time. And so it is important that people take the necessary precautions so that they don't, leave the burden of resolving all of these property-related matters and things like that after they are gone. So it's important that they prepare will as early as possible and consistently go back to it to update it as and when required.
Perfect. Sorry, one more follow-up for you. So you did mention cryptocurrency. Is the law still kind of up in the air about how cryptocurrency is determined in probate if someone dies without a will or anything like that?
Absolutely. And that's the thing. Like, I mean, again, people are even trying to locate their own cryptocurrencies, let alone, transfer that to, beneficiaries, right? So it's definitely up in the air. It is definitely one of those things that people are not fully aware as to the value of it, right? So, if you had bought, like I had a client who came in and said that they bought $500 worth of cryptocurrency in 2016, Bitcoins, 2016 or 2017. The value is like completely, shot up, and then obviously they're sitting on a lot of money right now. But again, if they don't take the necessary precautions, necessary steps to at least name somebody and to make sure that those things are transferred, again, it becomes difficult, even more difficult. Again, as you rightly pointed out, it is still up in the air, but even to go through the process, you'll need a lot of documentation, and I'm assuming the will be at least one piece of that documentation that you'll require. So,
perfect. Vidhu, you seemed very excited about the topic. Did you have anything to add?
Yeah, I was actually having a brainstorming session with my client because his spouse doesn't even know how much he has, and the problem becomes the tax implication, because right now the tax, there is huge tax implications on crypto gains, but there's also this developing notion of if you get a dual residency in a jurisdiction where crypto is not taxed, how do you bring it back? How do you use corporate vehicles around? Not anymore Apple and everyone who needs to be offshoring your residency in order to avoid taxes. It could be the common person. It could be that 22-year-old in that example, right? And then even if you have a will that's probated or a thing, how do you get these foreign exchanges that are holding this crypto to transfer it over? Because there's no beneficial designation. Do they recognize in their host countries this process? Like we're just coming into this world, and now throw in Web3 with the metaverse coming in. You have real estate on the metaverse coming in. This is going to be such a dynamic area of law. It's super interesting, but it's so dynamic and it's changing on a week-to-week, month-to-month basis. So what I tell you today could be wrong tomorrow. So if you're in that space, you have to understand that it's going to take a lot of planning and a lot of resources. This is not going to be your basic will or your basic POA to deal with these kind of matters. So it comes with the territory. So, get ready. Like this is going to be a wild ride in the next couple of years.
It always is. The law is always a wild ride. So the next question, sorry, I'm just scrolling through. So I guess this could be maybe for Abhi as well. Someone asked if you could give some info about appointing a successor for trading account versus a beneficiary and a contingent beneficiary.
So in terms of the naming a successor, and it also relates to the bank that you are actually using, or the facility, the service that you're using to actually do the trading, be it crypto or shares, it is, or ETFs. So it is basically going to be dependent on the institution that you're using. Some of the institutions do allow successors to be named in the account itself, just like how you are able to name a beneficiary or a successor in a GIC or an RRSP policy. But in some of the institutions that people are using currently, for instance, it could be US-based trading accounts that does not usually allow a successor. So that becomes a bit more complicated. The beneficiaries are normally never noted on the accounts, and so that's the challenge that you have to go through. And when you are selecting a trading platform, when you're doing crypto or other trading, you are I think you have to pay attention to whether your institution that you're going to be using allows for you to name a successor or beneficiaries as part of your account. So it's paying attention to those details when you're setting up the account. And obviously there are requirements now with US based accounts that requires more evidence, like in terms of ID verifications for individuals, even the account holders and beneficiaries. Your beneficiaries and the successors should also be willing to provide those details for you. They do require very specific IDs to be provided, more details about the individual. So again, there's a lot of issues with regards to privacy and confidentiality that needs to be paid attention to. And I believe when selecting a trading platform, all of these things have to be thought through before they sort of jump into it.
Perfect. So the next question is somewhat of a general question. So someone asks, why does the law always have a gray area, and why is it not so straightforward? Is it the intent to give work to the lawyers?
Else how are we going to pay our mortgage? Come on. No, because the law is always a reactive force, so it always has to evolve. So like things have always evolved in, let's say, nature a lot faster than what the law can catch up to. So when the law is trying to catch up, it's trying to bring in new rules or based on old policies, or try to mend into new areas where it's trying to use old tactics. So what it really creates are loopholes. It creates gray area. Plus, the people who create the laws want to benefit from it. Let's be real. So it's created with the system that there is a beneficial class here. So how are they going to benefit if they make rules that are going to be equal for everyone?
I think it's also to account for some context, right? Basically, if you create laws that are rigid and not able to account for the context of the situation, it misses the whole point. Like when it's, for instance, in an event like the one that just happened, when two parents fail to supervise how they stored a weapon in their home, if the only person that to be held responsible is the person that pulled the trigger, it should be the son, 15-year-old son, that actually pulled the trigger and killed the students at the school. But the gray area also allows for us to hold the people that could have otherwise also contributed to this crime, right? So without that gray area, which basically allows the law to hold people that were so irresponsible in storing and monitoring weapons, these people would walk. So I think it's also to provide context. And I understand that we all make a living out of that, but at the same time, it also assists the general public in a lot of ways.
For sure. Lawson, did you want to add anything?
Yeah, I agree with what both Avi and Vidhu are saying. But like Avi was saying, how I see it is it allows, the gray area allows for room for interpretation, right? If it was so black and white, things wouldn't evolve. Like stuff like Avi was talking about cryptocurrency. If we didn't allow for that into family law in terms of income and assets, and if we're just looking at tax assessments from like 20 years ago, a lot of things wouldn't be included in equalization payments and whatnot. If like we always say, it's not always a good guy and a bad guy. There's something that happens in between, right? And a lot of that has to do with that gray area. So judges allow. If you ever seen a lot of sections of the law, they'll have headings, and then at the last one, subheadings say and any other. It's in there for a purpose, right? So if you go to appeal a decision or whatever it is, the judge has the ability to then use that section to be like, you know what, I'm going to incorporate this. This is an exception to the law and include it. And that becomes a new law, right? So I think that gray area serves a purpose. And, it's yes, it helps us, right? But it also helps the people in the cases as well, because if we were still stuck in 1950, then a lot of things would be much different in court.
For sure. So Lawson, while I have you here spotlighted, I will ask you a family law question that was asked. So if you are separated, but I guess not legally divorced and nothing's been settled, and say the spouse is no longer in the country, anything like that, how would someone proceed with that? Like, how would someone figure out ways to either settle or figure out ways to obtain a divorce? What would be the first steps, and what would they need to know and look into?
So one party's like abroad and one party's is in Canada.
Yeah.
Well, like
for this example, let's say they're out of the country due to maybe a criminal offense or something like that. They were either deported or they're not allowed back into the country. That was how those questions worded. Yeah.
So there's the case must move on is what the judge always says. So like it's unfortunate the party's not there, but if you want to get your family law matter resolved, you would proceed with it as you normally would. Now, what would change is probably the service time and how you serve the individual and court appearances and whatnot. And so you still have a duty to. So if you're gonna, it's very unlikely that if the person is abroad and they're facing criminal charges and whatnot, that maybe mediation and stuff is acceptable. You probably have to go to the court process. So if you go to the court process, the timelines change as to how you serve the individual. Now, it becomes more difficult in the sense that finding where this individual resides to serve them and hiring someone, maybe say they're back home in Sri Lanka and you want to serve them in Sri Lanka, you have to find a postal server there who's going to be able to serve them, or you need them to be able to accept substitute service. A lot of times what individuals may do is they may go to court and bring a motion and ask for substituted service and explain the situation as to the party is not here, I want to serve with some materials, can I get substituted service? Judges are usually skeptical in the beginning because they want to see you show efforts that you've made to serve the party. It's because a lot of times people try to abuse it and say, oh yeah, I've tried. And the judge just says, okay, show me your efforts. What have you done? What's the last known address? Do you know family members? Do you know where he lives? Can you contact them? All that kind of stuff. So, and if that's the case and you get substituted service, the party has a responsibility to respond to the materials. And if he does respond, then there's ways for them to get incorporated into the court proceeding via video, or virtually or over the phone and participate in it. They would probably have a lawyer on ground here who would represent their interests. With that being said, there's nuances with regards to the applications and stuff and all, but I don't see there being much of a difference in terms of the actual substantive process of it. The procedural things may change. I don't know if I answered your question, if that's exactly what they were referring to.
I think that answers the question. I guess it's just procedural issues that might change. So somebody asked a clarification question about collaborative law, if I can find it here. So it says, the person asked, if you take a collaborative approach and it's not progressive, wouldn't it be disadvantageous as you cannot represent the same client further in court? So is that
disadvantage to?
I guess you as a lawyer, because you won't be able to continue to represent the client.
Sure, but like, a lot of times collaborative family law lawyers choose that path for a reason. They don't intend or prefer to go to court. There's a lot of lawyers who practice law in different ways. Collaborative family law lawyers are, and I actually, like, when I was in law school, I summered for a lawyer who was a really reputable lawyer who had done. Collaborative family lawyers are people who've practiced family law for a while, and they litigated, and then after a while they said, you know what, I want to transition and do something else. And she chose the approach of collaborative family law and being an ADR. She was an ADR judge or arbitrator, a mediator arbitrator, a parenting coordinator. So it's I wouldn't say it's disadvantageous. There's adversarial and litigious lawyers who want to fight stuff in court, and that comes from what the client wants. But then there's also lawyers who their main focus is to resolve the issue. So I wouldn't say it's disadvantageous. Now, whatever happens in a collaborative family law session, whatever materials are exchanged, that can't be used in court when you then go to court. So it's confidential information. It's meant for settlement. The same as if you're in court, there's settlement conferences that happen, but you cannot take settlement conference discussion to trial and be like, well, at the appearance, this individual said this, or his brief said this, because the brief gets just thrown away at the end of the day. So I wouldn't say it's advantageous. I just think it's dependent on the situation, right? If that's why I say you got to be careful as to what you choose. So if you feel like it's something that you can resolve through collaborative family law, then take it. But if you feel like it's not for you, then there's many options down the road, such as MedArb, which allows for you to do basically mediation, but also arbitration at the same time.
Perfect. And sorry to jump around between topics too much, but I just want to make sure we get through all of these questions. The next one's about wills. So I'll direct it towards Abi. Their question was, how do you draft or prepare a will that helps either factor into like the inheritance tax or help reduce that? Is there something that people can kind of keep in mind, or how they can plan accordingly for that?
There are definitely ways around it. It also depends on what you are actually bringing in under the will and what is being passed outside of the will. For instance, your insurance policies, your RSPs, GICs and stuff like that, which could actually have people named as beneficiaries, and that could be kept outside of the will, and that could be passed directly to the beneficiaries without having to go through the will. So that's one way. In terms of the asset being passed without or having to pay the taxes, there are definitely ways to manage business related matters by naming individuals into the corporation, bringing them on as shareholders prior to somebody passing away, which allows them to basically then take ownership of businesses. In terms of personal and properties otherwise named, or it's in the individual's name, it is going to be it's not going to be that straightforward to actually pass without having to pay the probate taxes. Again, if it is a spouse, usually there's a $350,000 asset value that could be passed on to the spouse. So that's one way of dealing with it. Joint tenancy is another one, I think will also help the spouse to take over properties that were held in the deceased name. If your personal properties or your real estate properties are held as joint tenants, it allows the joint tenant, if in the case there's a spouse, the surviving spouse is able to take over those assets without having to go through the estate process. So those are couple of ways, but it also depends on individual circumstances, I think, and it also depends on the exact nature of the property authority before we can say that this could be applied to save some taxes. Yeah. And they should definitely be consulting with the tax accountant. And this is one of those things that I strongly advise at this point in time, where there's a lot of wealth in the community that needs to be passed on to the future generation. It's important that they pay attention to what a properly trained tax accountant will provide. And there's also ways to now transfer some of those things to other charitable causes. Like there are a lot of people that I have assisted in basically preparing will that are now transferring some portion of their estate to charitable causes, like hospitals and hospital foundations and things like that. So there are other ways that you can actually continue to sort of transfer your legacy and to help the legacy to serve the community. So there's people can also look at that as ways to sort of mitigate the tax implications. Otherwise, their beneficiaries will have.
Perfect, thank you. So I guess we'll do our last question before we head to our poll question. And this question will be for Paul. Paul, I know for provincial offenses, a lot of people try to represent themselves or try to believe that they can kind of not get legal representation. When would you when should they consider seeking legal advice or seeking legal representation? How soon should they get someone involved?
Very simple question, it's hard to answer, but I will elaborate. Once this comes to a provincial offenses, I touch base with the criminal. Obviously, criminal, they definitely need a lawyers to represent or paralegal to represent them in order to advise and same as negotiate to make sure they are out of the criminal book. That's under the criminal codes. But once they go to the provincial traffic code, part one, of course, part one means anything moving simple violations. They got to try to save their license, but demerit points will hit also. So they got to negotiate that. If they can negotiate with the prosecutor to remove their points or remove the conviction or the charge to the minor, then it's fine. Otherwise, definitely they got to hire some legal advice in order to do that. And apart from there, the part three, where I have mentioned about insurance, they don't want to get charged $5,000 to $15,000 to $25,000, and also it might lead to a breach. But definitely they got to have the legal representation to negotiate with the prosecution, because the prosecution will not conduct with the public non-judicial pretrials. So therefore, they definitely need a legal representation in order to minimize that. The major issue, either criminal code or provincial traffic code, they got to understand how to read the disclosure. Is that the disclosure is fully given by the prosecution. If it is failed, obviously case is dismissed. Who could do it? General public have no knowledge about that. So that is one of the charter rights in order to get the full disclosure to proceed further. I have dismissed many cases having a lack of disclosure or not provided in full. So that will help for the people to get the legal representation on that point. Thank you.
Perfect, thank you. In the interest of time, I believe that will be the questions. I'm so sorry if I missed. There are a few questions I do see that I've missed, but time just does not allow for everybody's questions. Hopefully we can keep doing more sessions like this and being able to answer more questions and getting people more involved and providing more information. At this time, we will have a few poll questions that will appear on screen. If you can all take a few minutes to answer it, that would be greatly appreciated. Okay, perfect. Thank you again to all of our speakers and for everyone for joining us today. We hope this seminar was very informative and that you have a better understanding of the areas that we touched on today. Please feel free to provide your feedback on our programs and what you'd like to see in our future events and what topics you'd like for us to cover. Our next planned seminar will be on mental health, so follow SACEM on social media to get updated about that. And thank you again to everybody, and I hope you enjoy the rest of your day.
Thanks for the opportunity.